Chris, you're asking everybody to come in? Terrific. But we're going to get started. So our next step is for understanding long-term care. Kathleen Kienitz, certified elder law attorney in Lewiston, and is a member of the National Elder Law Foundation. She's one of the first elder law attorneys in the state of Maine. She has practiced elder law and estate planning since 1991, providing a broad range of legal services to senior citizens and their families. She has served on the National Elder Law Foundation Board of Directors and is past chairperson of the Maine State Bar Association Elder Law Section, and a board member and vice chair of Maine's Legal Services for the Elderly. This is such a critical topic that people sometimes just don't want to recognize or have to deal with. Kathleen will provide tips for long-term care planning, discuss different long-term care options and their benefits, with the details that everyone should know when they're planning their long-term care strategies. Ladies and gentlemen, please welcome Kathleen Kienitz.
Thank you. It's a tough act to follow, Susan Collins. So hopefully you've been infused with caffeine and energy, and I won't put you to sleep. So yeah, I've been practicing now for 30 years. God, that makes me feel old. And this topic is near and dear to my heart. Yeah, I too have been affected. My father had Alzheimer's or Alzheimer's type dementia. He was a brilliant man. He did the every Sunday. And as he started setting in, he would continue trying to do them, but more feebly, and then finally he just drew little pictures on the corner, and I never actually realized what a good artist he was. It was like, where did this come from? And he was also a real punster, and the other thing that sort of surprised me as his disease progressed was that a lot of the puns would just be repeated over and over and over, and but every now and then he'd come up with what is going on in that head, and it's just amazing to me kind of how certain things stick around. But yeah, eventually he'd say, "Who are you?" And I'd say, "Kathy, I'm your daughter." And he'd say, "Catty?" And I'd say, "No, Kathy." Say, "Catty? No." And he would repeat that over and over. Then 5 minutes later, same thing. And, it's I look at it as a disappearing disease. You see the person that you love disappearing. Their body is still there, but the person who you know is disappearing. So I am going to, this is a lot of stuff to cover, so I'm just going to breeze through and give you some tips for things that come up in my practice all the time with people who come for help. And let me just explain elder law briefly. Elder law, I think, really came about as a factor of the fact that people are living a lot longer. And really, it's a pretty new practice. It's only really been around for 25, 30 years as a specialty area. It was not something that was offered in law school when I went, and now I think pretty much every law school has a course on elder law. It encompasses everything that you would associate with estate planning, wills and trusts and all of that kind of stuff, advanced planning, but it also encompasses long-term care. Long-term care planning, we're talking about what happens when we have to place a loved one in a nursing home or long-term care facility. How are we going to pay for that? What programs are available? And we're dealing with agencies, and there's administrative law involved with that. And that's sort of the thing that sets elder law attorneys apart from your bread and butter estate planning attorney. This is just my little disclaimer. My associate attorney put that in there just to say, you can't rely on anything I'm telling you right now and sue me because it's turned out to be wrong. Whoops, what did I do? Okay, so what I'm going to be breezing through today are what I call the basics, and this is, again, what a basic estate plan should encompass. And it's basically three things which we'll talk about: your will, your durable power of attorney, and healthcare power of attorney. And those two later ones, durable power of attorney and healthcare power of attorney, are really critically important when people are facing aging and worrying about what's going to happen if I'm no longer able to make my own decisions. And then I'm going to talk a little bit about long-term care planning. And again, when we talk about long-term care planning, we're talking about really, in a nutshell, how do you pay for it and how do I plan to pay for it and not go broke. And then I will save some time for questions. Okay, so the will, a last will and testament, that's something that everybody should have. It's something that everyone kind of knows about, but there are a lot of misconceptions about. I've had clients come in and do wills, and then after the fact, when someone dies, maybe their spouse, and they find out that there is a probate that's going to be involved, they're angry at me because they said I did a will. I thought that avoids probate. And so that's one common misconception I want to clear up, is that a will is not a way to avoid probate. Probate is a process actually of and there are with most married couples, for example, there's no probate. I'd say in 90% of cases with married couples, there's no probate. And the reason for that is because usually married couples have things in joint names, joint tenancy with right of survivorship. For instance, your real estate, if you're married, is almost, always jointly titled, so it's going to devolve to the surviving spouse automatically. And likewise, things with beneficiary designations like life insurance and IRAs, 401ks, those beneficiary designations are going to control who gets that asset. So again, with most married couples, you've got everything jointly titled or with beneficiary designations, and so a will is not going to come to play. But a will is very important if the person who has died has got property in their sole name and there's no beneficiary designation. And so that, again, will determine who gets the property, and also very importantly, who's in charge of the probate process, who's going to be holding the helm and, making sure bills get paid, ultimately the wishes in your will are carried out. The probate code, which is sort of the recipe book, the statute for the probate laws and how wills are interpreted and how the whole process is supposed to happen. It's going through a massive overhaul, which was supposed to go into effect in July, and now it's been pushed to September. One of the big changes, which is kind of nice, is that if the estate has more than 40, let me rephrase that, if the property in the decedent's name with no beneficiary designation is less than $40,000, then probate is not necessary. There's a very abbreviated process that involves just having an affidavit. That used to be $20,000. As of September, it's going up to $40,000. So a will, again, living trusts are a possible, but that's not a magic bullet either. A lot of people think that if they have a living trust, it's going to, just do all this magical stuff like avoiding probate and protecting property for long-term care purposes. And trusts are kind of complicated legal documents, and they can be great. You can do all sorts of things with a trust that you can't do with a will, like controlling your property from the grave. With your will, once the property is distributed, that's it. Whoever gets it then does whatever they want with it. With a trust, you can tie things up for really as long as you want to, with whatever strictures you want, and putting whoever you want in control of that process. So that's a little beyond what we're going to talk about, but I just want to throw that out because that is one way that probate can be avoided. So for this purpose, for this group, again, I mentioned the financial power of attorney and medical power of attorney, and those are the two ounce of prevention, the two preventative things that, if possible, if you have any loved one who has beginning stages of dementia or Alzheimer's, please get those in place, because you will avoid a lot of headache if you have them in place. With the financial power, which is usually called, you'll see on most of them, they're called durable power of attorney, which is kind of ironic. The reason that term durable ever came around was because back in the old days, powers of attorney were possible, but as soon as a person became incapacitated, the power of attorney no longer was effective. Doesn't make any sense, does it? I guess was that if you had, people would go to Europe for 3 months at a time, and so they would give someone back home power of attorney to manage their affairs. And so the idea was, well, you know, if I have lost my capacity, I don't want that to be in effect anymore. So anyway, 30 years or more or so ago, the law changed, and so statutes much in every state, I think, that said that if there's language in the power of attorney that says that it's durable even in the event of incapacity, then it stays, you know, working in the event of incapacity. Nowadays, all powers of attorney are durable, but that word durable, it's still there in most powers of attorney, just to confuse people. So your typical power of attorney, financial power, I like to call them financial powers of attorney, and I've seen some offices, some attorneys that will put medical language in a financial power of attorney. You can do that. I mean, there's nothing wrong. Well, there's nothing, you know, it works is what I'm trying to say, but I don't personally like that format because they serve two very different purposes and they go to two very different types of facilities or institutes. So with a financial power of attorney, you want to use that primarily with, again, financial institutions, so banks, for instance. So if you have a financial power of attorney for somebody who no longer can pay their own bills or manage their financial affairs, what you do with that written document that they've signed appointing you as their agent is you take it to the institution where you want to use it. They take a copy and put it on file. They take your signature, and then you're able to write checks or do whatever at that financial institution that the person holding the accounts there can do. And likewise, if you need information, I help people with Maine care applications all the time, and so often people need information from life insurance companies, for example, to show what the cash value is, or they need information from Maine State Retirement, for example, to show what the gross monthly benefit amount is. And that's the sort of thing that even between husbands and wife, you call Maine State Retirement or you call the life insurance company and say, hey, I need my husband's, you know, whatever. They're not going to give it to you. So, you know, a lot of people think, well, you know, I don't really need it because of my husband. We do everything for each other, but not true. There are many instances, like the two that I just mentioned, where you will be stonewalled if you don't have a power of attorney. And so what do? So what you do in that case is so much more complicated than just getting the power of attorney in the first place. You go to the probate court and you file a petition for guardianship or conservatorship. And I'll explain the difference. Guardianship is the authority granted by a court to make decisions about the person's health care, welfare, maintenance, placement, medical kind of things. In Maine, we call that guardianship. And conservatorship is having control over the person's finances. And so there are two different roles. You can petition the court for both of them or one or the other. But again, it's so much more complicated than having the power of attorney in place, and particularly for financial matters, because if you have to become conservator of someone, not only do you have to go through the process of filing the petition and getting bonded and notifying a whole bunch of people that the statute says you have to notify, and then having a hearing and having the person notified, and it's expensive. But then you also have to report to the court annually with an annual account, which is really onerous. And I've had cases where someone didn't know that, and 10 years have gone, and then they find out that they need to account and try to account for everything you've done with finances for a 10-year period. So again, it's just a classic ounce of prevention. If you have a power of attorney, then you're not going to need conservatorship unless there's some sort of fight. You know, if it's a dysfunctional family situation and one person is abusing a power of attorney, well, then, you know, petitioning for conservatorship might be very wise and necessary. So the power of attorney they're also controlled by the Maine Probate Code, and the Maine Probate Code sets out all the things that an agent under a power of attorney can do. It's very broad, very extensive, but it's not everything. And so there's some authorities that you have to specifically put in the power of attorney if you want your agent to be able to do. One of them is gifting, transferring property out of the person's name. Another is trust authorities, like setting up trusts or amending trusts. Another is changing the beneficiary on any kind of a document or account that has a beneficiary designation. And then another one is being able to delegate authority to someone else on a temporary basis. So those are some of the optional powers that we do put in a power of attorney, but again, it's expansive, it's broad, and you absolutely want to be sure that the person that you're appointing is trustworthy. Powers of attorney can be, they can go into effect as soon as you sign them, or they can be what are called springing powers of attorney, and there would be language in the power of attorney that says this document does not go into effect until, and it's usually something along the lines of my primary physician has certified that I'm no longer able to handle my financial affairs. My personal preference is not to do springing powers of attorney because it often leads to red tape situations. For example, if someone hasn't seen a doctor for 1 or 2 years and the doctor has no idea what the person's mental status is, good luck with that. Or, you know, if the doctor feels differently than you do about whether the person is able to act or not. And so the bottom line, again, that I tell clients is that if you trust the person, then you shouldn't have to worry about them abusing the power of attorney. If you don't trust the person enough to know that they're only going to use it as you would want them to, you probably shouldn't be naming them in the first place. But, you know, it is an option, and sometimes people have a reason to make it a springing power. So, joint accounts. So, I think I might have another slide about this, but a lot of people will put a child, for example, on their bank accounts for convenience, just so that they'll have access to the account, so they'll have, you know, when they die, they will be able to use the account to pay for the funeral, that sort of thing. It's a really kind of messy way to do estate planning because with a joint account, as I was describing earlier, they carry right of survivorship. So if you die, the joint account owner becomes the property owner. And even though you might have only put them on there for convenience, unless there is clear and convincing evidence that that was the reason you put that child's name on your account as a joint owner, it's their property, and they can take the property and run if they want to. And clear and convincing evidence means something, usually what it means is something in writing that makes your intent very clear. So, I mean, I've had many cases where a child was on the account and the person died and they said, look, I know this was meant to be distributed according to my parents' will and that's what I'm going to do. But I've had other cases where the child has just said, hey, you know, it's mine. So that's financial powers of attorney. The adjunct, the medical adjunct to that is the healthcare power of attorney. And so in Maine, we have Maine healthcare directives. You've probably seen these documents. Most doctors' offices, most hospitals, medical facilities have them. And they follow a statutory format that's pretty standard. That's one of the reasons I don't like having the medical stuff put in a financial power of attorney, because most medical providers these days have come to recognize the Maine healthcare directives, and it's a very straightforward document that's familiar. And the first part of it is allows you to appoint an agent, just like you do in a financial power of attorney, to make your medical decisions. And it also allows them to access your medical records and to talk to your medical providers and make, be your medical advocate. That's very important. In my opinion, that's the most important about the advanced directives, the Maine healthcare directives. The other part of that is what we used to call a living will, where you specify what you want or don't want at the end of your life. So it talks about the various scenarios that would maybe constitute the end of life. For instance, you're being unconscious and to a medical degree certainly will never regain consciousness, having, being terminally ill with, the prospect of usually there's some sort of time frame, or when the risks and burdens of treatment outweigh the benefits. And so with that sort of definition of end of life in mind, then you go on to say that I don't want to be kept alive by artificial means, and then the two specific ones that they usually have check boxes for are artificial hydration and artificial nutrition, which, those are the two classic things that will keep a dying person alive for weeks or months even. So you can opt out of any of that. You can customize a healthcare directive to your wishes, really. But it's an important thing to do. And again, if you have somebody facing long-term care, Alzheimer's, if you can get them to get that done while they still have their wherewithal to do it, it's so important. It also gives you, there's a spot, an optional spot where you can make preferences about organ donations or donations of tissue parts or body parts. And there's also a section that says that, and this is actually similar to the financial power of attorney, that says that if anyone petitions the probate court to become your guardian, that the judge has to give preference to the person you've named in this document, unless there's very, very good, reasons not to do so. And likewise, as I said, there's a provision like that in the financial power of attorney, and it's to prevent someone to come in and try to usurp your choices about who you've, decided you want to manage your affairs. You can also make your funeral preferences known. We've put a section in the one that we've sort of customized where you can make choices about things you might want if you are at the end of your life and are no longer able to express your choices, like the types of music you might want played, or pets that you might want to visit, types of flowers you don't want brought, any of those types of things. And, chances are your family members know all of this anyway, and the agent that you're naming knows it anyway, but it's a good exercise for everybody to go through for their own purposes and to, open up the dialogue with your family members or loved ones. So, long-term care planning. This, again, is the kind of the meat of a lot of elder law practice. And so this is, I'm going to just breeze through this because we're running pretty late. So with long-term care, people are usually shocked, the sticker price shock. It's extremely expensive. In Maine, nursing home care costs over $9,000 a month. Residential care, which is kind of a newish thing, Maine helps pay for that, but residential care has become largely associated with memory care. And so places, I practice in the Lewiston area mainly, but we have a huge facility called the Woodlands, which is strictly memory care, and they're cropping up all over the place because, again, it's becoming such an issue as baby boomers are, aging out and coming down with these long-term dementias. So residential care typically costs about $6,000 a month. Medicare pays for very little long-term care. Medicare will pay for up to 100 days in rehab-type situations. So what that means is that you have to have been in the hospital for at least 3 days. You have to have the need of have continuing skilled care. Doctor has to certify that you need that care, and there are a couple of other factors. So if you qualify medically and you go into a facility that offers that kind of care, you can receive Medicare to cover it. But that will only be for up to 100 days. And typically the facility will have to recertify that you continue to need that care every 10 days or 2 weeks, I don't know exactly. And so in many, many cases, you never even get your full 100 days because the facility and the OT people that are offering the services will say that you've maxed out, that you're not getting any benefit. An important note on that, nursing homes have been infamously guilty of doing that prematurely. And I think the reason for that is because they get audited and they're always, they're worried the federal government's going to come around and say, hey, we shouldn't be paying for this. This person didn't need this level of care. So there was a case brought by the Center for Medicare Advocacy. It's a great group in Washington, D.C. If you ever have a Medicare issue, you can look them up. They have an 800 number, and they're really very helpful. But anyway, they filed a class action lawsuit called the JIMO case. And they got a declaratory judgment that if a nursing home says that you've plateaued, that is not an adequate reason to terminate your Medicare coverage. And so this is an important area for advocacy. So I find that nursing homes are using that term less and less, but the standard under this case, JIMO, is that if the skilled treatment, and that usually equates again with physical therapy, occupational therapy, that sort of thing, if that skilled treatment is helping the person attain, and this is key, their highest level of functioning, then they need to continue those services. So, if a provider says, or the team at a, rehab facility says, oh, they've plateaued, they're getting no benefit, make an inquiry. If you know that your loved one is still participating, engaging in the PT or the OT, they're still doing it, they're still cooperating, and it's keeping them going, they're supposed to continue the services. So that's just an interesting side note. So Medicare will terminate after 100 days. After day 21, there's a huge copay that kicks in. I think it's like $155 a day. That's where Medicare supplement insurance becomes very important because, insurances like Blue Cross Blue Shield, Anthem, Unum that sell Medicare supplement policies, typically ones, but the most common ones people get will cover those huge copays. So we talked a little bit about the different levels of care let me back up a second. So when you run out of money, or I shouldn't say when you run out of money, let's just talk about when you might qualify for Maine Care assistance. Maine Care is Medicaid. Medicaid is a federal program. Every state has it. And we call it Maine Care in the state of Maine. So Maine Care does cover, but it's a needs-based program, and you have to qualify financially. Okay, yeah, I'm skipping ahead here. So here, the basic financial eligibility criteria are this. If you're an individual who's single, you can only have $10,000 in countable assets. There are non-countable assets, and the big one, to the surprise of a lot of people, is your home. Even as a single individual, your home is exempt. All you or anyone filling out your Maine Care application has to do is to say that you intend to return home. And it doesn't matter how unrealistic the intent is. They cannot make you sell your home. And they don't have a lien on your home. But we're going to talk a little bit about the home, what happens after you die, in a minute. If you have a spouse, the rules are more generous because the government recognized that the spouse still needs to be able to live, and so the spouse is allowed $126,000 and some change, and that's in addition to the $10,000 that the applicant is allowed. And so that's really, really important because I have encountered people who didn't know that and thought that they had to spend every dime before they could get assistance for their husband or their wife, and that's a really tragic situation when they have spent everything practically and didn't need to. So in addition to the house, one car is exempt, and that's true, again, even for a single individual. And irrevocable mortuary trusts of up to $12,000 are exempt. It does have to be irrevocable, and this, what I'm talking about is when you go to a funeral home and you sign a contract for the services that you'll have after you die, you pay for it, and then the money is put in a trust account in a bank somewhere. So that is not a countable asset. Most other assets are countable. An interesting one that's not countable, and it's rarely used, is income-producing property. And I've had exactly one case where a man was, his wife had to go into a nursing home, and he went out and he bought 3 apartment buildings in Portland. Yeah. Most people, when they're, facing that stage of their life, are not interested in becoming landlords, but this guy did, and it worked. So, a big area that we talk about when I see clients and when I do presentations like this is giving away money and what are the effects of that. Up until 1993, you could you could give away all your money, or as much as you needed to give away to get down to the asset limits, and go and apply for Maine Care, and it was fine. That changed in 1993. There was a broad OBRA, Reconciliation Act, and that changed, and that's when transfer penalties were implemented. And it started out with looking back 3 years, and then that was eventually changed to, it was 30 months, and then it was changed to 3 years, and now 5 years. And I keep having clients coming and saying, is it 7 years now? And I don't know where that rumor started, but it is not 7 years, and I would love to know where the rumor started, because as far as I know, there's absolutely no truth to it. And the Maine Care, believe me, those DHH workers are so having to deal with 5 years worth of financial statements. I just can't imagine that they would, up it to 7 years. So what that means is that if you are applying for Maine Care assistance for long-term care, and this only applies for long-term care, not for for community-based care, the state is entitled to require you to provide 5 years worth of financial statements. And the reason that what they're looking for, and what they ask for too on the application, is have you made any gifts or transfers or sold anything or disposed of anything? I mean, it's just this very broad question. And so if you have, including sold something for less than fair market value, you're going to be penalized. And the way they penalize you, sorry, I wasn't sure what the next slide was. The way they penalize you is they tally up the value of what you gave away, and they divide it by the average monthly cost of nursing home care. The figure they use for that is $8,476, roughly $8,500. They have not updated that figure for years, but that's another story. So they divide what you transferred by that amount, and that is the number of months that they are going to say, sorry, but you're not qualified for that number of months. So for example, if you gave $85,000 to your kids 4 years ago, and you're applying now for Maine Care for your spouse, because of that gift of $85,000 4 years ago, they're going to say, sorry, but you need to wait 10 months before you'll be eligible. It hangs over your head until the 5-year point, after which you don't have to worry about it anymore. And that was another big change in the rules that came about maybe 10 years ago, is that it used to be that the penalty period started when you made the gift. So you could plan on, okay, I've got enough, to get through those 10 months, and after that, we'll be fine. No longer the case. It hangs over your head. If you applied 4 years and 11 months after the transfer, guess what? You're going to be ineligible for 10 months, which is going to put you at 9 months beyond the 5-year look-back period. So it's a very kind of onerous rule. So for people who really, really want to leave a legacy for their children or whoever, and they have, planned well in advance, you can give away as much of your property as you want. There's no law against making gifts or giving property away. But you should do it very carefully with that mind. And so if someone comes to me, I will grill them about what their health situation is, what they have for other assets, and look into the crystal ball, so to speak, to see how the next 5 years might look, and making sure that if I'm advising transfers of assets, I'm going to want to be pretty confident that they're going to make it through that next 5 years without, finding themselves up a creek without a paddle. So there still are planning strategies, and there are more planning strategies for a married couple than for a single individual. One of the planning strategies involves the use of an annuity, and I'm just going to breeze over that just so you kind of register that it's a possibility. And it's not the kind of annuities that are so popular being sold, the deferred annuities. It's a very restrictive, special kind of annuity called an immediate annuity. And the reason it works is, I don't think I mentioned the income. So if one of you qualifies for long-term care assistance, your spouse's income is not counted. They don't have to apply their income toward your care at all. And in fact, if their income is low enough, roughly $2,050, I think, you might be able to keep some of their income. So the spouse's income is exempt, and that's how the annuity thing works. So what an immediate annuity does is it allows the spouse to take a chunk of money, presumably the amount of money that they're over the asset limit, put it into an immediate annuity. That immediate annuity is going to create a stream of income over some set period of time. And it basically converts a countable asset into a not countable stream of income for the spouse. Again, it only works in a couple situation because they don't count the income of the spouse. So there are restrictions, and it's very important that you know those restrictions if you're ever going to use this strategy. And one is that there has to be a payback provision to the state if that spouse dies before the annuity has paid out in full. And so for that reason, when we structure these things, we usually have it pay out over a pretty short period of time, like 2 years, so that hopefully it will have paid out before that spouse dies. And the other important thing in understanding this annuity strategy is that once the nursing home spouses become eligible for Maine Care, they don't look at the assets of the community spouse. So the community spouse might be getting $10,000 a month in annuity payments for a period of 2 years, and they can just bankroll that money, and it's going to put them on a asset limit, but it doesn't matter because that spouse has already become eligible for Maine Care. Trusts are something that we do sometimes use too. They have to be irrevocable, meaning once you set it up, you can't revoke it. And once you put property into it, you can't very restrictive, because if it's not, the state will say, you can take this out, you can use it, we're going to count it as an asset. If you do use a trust for that purpose, it's going to, involve the 5-year look-back period, because you're basically giving that money away to the trust. We often use them for homes or vacation property. Those are two kind of probably the most common uses that I use irrevocable trusts for, because the property can be put into the trust and the person who transferred it can still live in the home. And there even is last-minute planning that is possible. So say that, there's no way that your father or your spouse, whoever you're concerned about going into a facility, is going to make it through 5 years. In those cases, what we often do is say, come back when nursing home care is imminent. And that seems so counterintuitive, but the way it works is when nursing home care is imminent, then we have the person make the transfer to their trusted child or whoever. Transfers between spouses, by the way, are exempt. You don't have to worry about transfers between spouses. So it's usually a child or a couple of children who the transfer will be made to. Then we apply for Maine care, and we know there's going to be a penalty period. And we do that purposely. We want to start the clock on the penalty period. And so with the clock started on the penalty period, then the trusted child will give money back to the parent as needed to pay for their care while the penalty period's running. And so people say, yeah, but they're going to end up giving it all back. And no, they don't have to give it all back, because every $8,400, $8,500 roughly that they give back is going to wipe off a month of that penalty period. So you're compressing the initial penalty period. So maybe you initially had a 10-month penalty period, but because of money that had been returned, it's been reduced as the clock is ticking to 5 months, at which point we reapply for Maine care, prove what's been given back, and then they're eligible, and whatever remains of the assets is protected. And it's not a slam dunk, but it is a way to save a chunk of the estate. And there are other things like supplemental needs trusts for disabled children, which, by the way, a supplemental needs trust is a trust that can be set up for someone who's disabled, and it won't interfere with whatever public benefits that person is receiving. So transfers to supplemental needs trusts are completely exempt from the transfer penalty rules. For anybody, it could be a grandchild or your next door neighbor. If it goes into a supplemental needs trust, it is an exempt transfer. Transfers to a disabled child are completely exempt. So that's often one of the questions we ask is, do you have any disabled children? We call that the name your child law. Nobody's with me anymore. Nobody laughed at that. We don't really. So there are always planning strategies, even, as I said, even when nursing home care is imminent. So I mentioned the house and how the state won't take your home. They can't take your home. They don't even put a lien on it. But if you die and you've been in Maine care and you don't have a surviving spouse, then they're going to put a claim on your home. And the way they do that, it's very low-hanging for them. The home will have to be probated if it's in a single person's name, and they just swoop in and they make a claim in the probate court, and the personal representative has to deal with it, or they're personally liable if they don't. So the home is, potentially vulnerable. If you have a surviving spouse, they can't go after it. Even if the surviving spouse dies shortly after, it obliterates any ability for the state to make a claim. If you have a disabled child, they can't go after it. And this is really kind of ironic because the will doesn't even have to leave everything to that disabled child, but just by virtue of the fact of having a disabled child, it disallows the state from making a claim. So we talked about putting your house into someone else's name in the context of transfers of assets, and you have to worry about the penalty periods, and also a potential problem there is if you have a number of kids and you want all of them to, share in your estate, and you put it in one kid's name, then you're putting all your trust that that kid's going to properly deal with it. And then they've got gifting issues. So if, in a case like that, it's probably better to think about a trust. So some of my easiest cases are where people have just one kid. And it's like the 4 or 5 or 6 or 7 or 8 where things get, you have to really be careful about what you do. So I will leave it at that. If anybody has any questions. Yes?
So when the state goes after, makes a claim on the house, is that a dollar for dollar claim?
Yeah, the question was when the state makes a claim against the house after you die, it is dollar per dollar. They will have a long readout of every penny that they've paid. And it still will be less than what you would have paid because the state reimbursement rate to facilities is significantly less than the private pay rate. But yes, they want every penny back. If there's not enough there to pay it all back, they're not going to get it. And there are certain exemptions. For instance, if there's children, they're entitled to $7,000 off the top, regardless of the state's claim. And then, of course, things like funeral expenses and the cost of administering the estate come off the top as well. Yes, in the back.
I'm wondering, how do single people, no family, no assets, how do you arrange to get care for yourself when you're older?
So the question was, if you're single, how do you arrange to get care?
Single and you don't have any assets, you don't have any money to put back for that, you have very low income.
Mm-hmm.
Then how do you designate somebody for power of attorney, because you can't do that? How do you plan for what kind of facility you're going to go in and get it paid for? In other words, if there's no one around to do that, are there options?
Right. Did everybody hear the question? Okay. So for starters, I would see an elder law attorney, just schedule a consultation. And if you have anybody, if you have a church and you're close to somebody in the church, or you have a close friend, those are always options. If you don't, I will do it for people, but I'm going to grill them and make sure that they've ruled out any possibility before, I or my associate will take that on. Because we'll charge for it, and most family members won't. But it's important to talk about it and get the documents in place. There's always somebody that you can name.
There's social workers usually in the hospital too that come around and talk to the individual and ask them if they have children or whatever. But they will contact appropriate sources in some cases if they don't have anybody else to.
If you end up in a hospital and you're all alone and have nobody, there will be social workers and people that will they're not going to throw you out on the street, and they're going to find an appropriate placement. But, people, in my experience, are always ahead of the game if they have someone who advocates for them. And I really think that's true, that the people in nursing homes, for example, who get the best care are the people who have someone looking in periodically and just making sure things are being done and done correctly. Yes?
In making out a will, and I have no family here, no children, is there an advantage in leaving things to your estate as opposed to an individual?
So if you leave things to your estate, they're still going to go to an individual or individuals. So if you leave things to your estate and you haven't specified who are the beneficiaries of your estate, then the probate code is going to dictate that. It's logical. It's not. Some people think that if you don't have a will, it goes to the state. No, it does not. So it's logical, and so if you have a spouse, it goes to the spouse. If you have children, it goes to the children. If you don't have children, I think parents come before children, but that hardly ever happens, where the parents are there but not the children. So it goes down the line, it goes down the family tree, and the cases that are really crazy and difficult are where people have and they have a bunch of deceased aunts and uncles on both sides, and some have children, and then you've got to literally go down the lines of the family tree until that line stops. So you might have an uncle who had 3 kids, and 2 of them are still alive, but one died, and that one had 3 kids. So you've got to, again, go down the line. I've literally had cases where I've had like 30 people that had to be notified, and half of them were person. So those are the cases where it actually makes sense to have a trust, because even if you have a will in that situation and you leave your property to very specific people, you still have to notify those blood relatives. It's kind of crazy. Yeah. Yeah.
Okay, a question just occurred to me. If you have stipulated that you want a medical trust set up for a child who's an adult child now, I'm just wondering, does the term disabled ever change in law, or how does the person that child sets up as their financial power of attorney and all of that, how do they assist them in making sure that they're safe within the medical trust, that they are going to be safe and have assets covered and all of that?
Okay, I think you're talking about a supplemental needs trust, which is the kind of trust I mentioned that you can set up for a disabled person without interfering with their public benefits. So first of all, you have to appoint a trustee.
Yes.
And that person will be in control of the money. You can have substitute trustees, as many as you want.
Right. I'm just concerned, does the term legally ever change from the state as to what is disabled? Like, what's disabled now, does it change later?
Yeah, so what's disabled now is, it's defined by the Social Security definition of disability. And so easy cases, receiving Social Security disability or someone who's receiving SSI, both of which, require that to be controlled by the Social Security Administration. A more difficult case is but for whatever reason they've never applied, and there is supposed to be a mechanism where DHHS will make a determination. It's very cumbersome and it doesn't work very well. So it's usually the cases where there's already been a Social Security determination of disability. I don't see that changing, but if it did and you had previously set up a supplemental needs trust under current law, it should still hold.
Okay, thank you.
Yep.
Question, what would be a ballpark figure, the cost to meet with an elder attorney like yourself, say to draw up a will and a couple of power of attorney documents, and you don't have a huge estate, your house, a small bank account, etc.? Rough ballpark figure.
Yeah, I mean, it should be under, for a couple, it should be under $1,000, I would say. Every situation is a little different. We always start out with a consultation, and we do charge a fee for the consultation because sometimes people come and that's all they need. And, we spend 45 or 50 minutes with them, and I don't hold back information trying to tease them to come back in. I answer the questions and give them whatever information is relevant that I can spew for. So, any other, yes?
Just to try to clarify, if someone has already been deemed incapable of caring for their finances, etc., one has to go through guardianship at that point. I mean, for power of attorney, those things have to be gained by the person who needs the help.
Right, so yeah, in order to sign a power of attorney, you have to have capacity, legal capacity. I've had people who've had very borderline legal capacity sign powers of attorney, but if I do that, I for sure that it's not, a hornet's nest of family dysfunction. If I know it's an intact family or just a husband and a wife, I will kind of do the straight face test. Worry of doing that again if I knew that there were warring factions in a family. Yeah.
I just want to say, as a healthcare professional, much of this information has been, all of the information is extremely important. It may have been stressful for some of you here. So please, when you leave here, make sure you are taking care of yourself. Drinking some water, taking a nice deep breath, listen to the birds outside, and just then share the information. That's all.
All right. Thank you very much.
Thanks so much.
You're welcome.
Really appreciate it.
Yeah. Here's the clicker.
Okay.
Okay.
You should take a look at the PowerPoint presentation because, as Kathleen has mentioned, eldercarelawmaine, eldercarelawmaine.com also has resources and information. I want to thank all of you for being here. This is very important to the foundation that we hold these educational conferences, going back to why we were founded, when our board chairman, who's our founder, Bert Brodsky, had no place to turn to when caring for his mom. He just wanted to make sure nobody goes on this journey alone. And while our model is care, education, and research, this education is so critically important to us. And this is why we've been in more than 40 states throughout the country in the last 2.5 years, that we want to empower you, and we want you to know that you can turn to the Alzheimer's Foundation of America for guidance, counseling, and support. So as she said, take a deep breath before you get up, and thank you so much for being here.